Good morning, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. We'll start in Michigan. Judge Dad has a pretty full house this morning, it looks like.
A stipulation, what are you guys are settling it? Am I understanding correctly?
That is correct.
Oh, okay. So I adjourned it a week. Well, I wish I wouldn't have brought these home to read them. That's okay. I think the motion's up today, right?
Yes, it was up last week as well.
Okay, yeah. All right, so what do you want me to do? Tell me what you want me to do. This case,
It's gonna be there in the next 2 hours. So you can either adjourn it another week or
Jennifer, just give me a
Hold on one
give,
second.
give me a date in July.
Judge, do you want to just do July 7th, your LT day?
No, you can go further. They're going to settle.
Okay.
July
14th.
7th. What do you have, the 17th?
The 14th,
14th at
8:30.
8:30. So I'll have their order and we can cancel this. Okay, July
Sounds great.
14th at 8:30, ladies and gentlemen. Have a good, anything else?
not complaineth.
Not from defendant.
Thank you very much. Have a good day, you guys.
Thank you.
too.
Discover versus Hazy. Discover Bank versus John C. Hazy, 2500496.
Good morning, Your Honor. J. Baig, BAIG, P36820 on behalf of plaintiff.
Is John Hazy here?
He was here. I spoke with him.
And then he left? Oh, there
No,
he-
Judge, it bumped him into the breakout room.
Okay, Mr. Hazy,
Well-
your name?
Yes, John Hazy.
Good morning. Did you two
Morning.
talk?
We did. He's got a debt settlement company, Beyond Finance, and they're trying to negotiate with Discover. I told them we're just seeking a judgment today with our motion, and negotiations can still continue, but we want to solidify our position here. So that's where we're at. I still want to go ahead with my motion.
Well, and I did not receive a response from you, Mr. Hazy, correct?
I'm not sure if Beyond Finance, their legal team reached out through all this. We've been working and getting offers from Discover through Beyond Finance, and we just haven't accepted it yet because we just haven't agreed with the terms and just haven't been able to reach the terms yet. So we're trying to negotiate, get more time. Like I said, I'm in
All
that-
I'm asking you is you didn't file a response to his motion for summary disposition, correct?
No.
Okay, you can go ahead and proceed, Mr. Baig.
Yes, just briefly, this is a C9, C10 motion. We've submitted documentary evidence showing use of the account. It's a Discover account. This is the original creditor. He hasn't filed any response with any counter evidence. So at this time, we're requesting that our motion be granted. Thank you.
Any response, Mr. Hazy?
No, as of right now, I was waiting for another response from Discover to. I don't know. This is my first time doing any of this, so I have no clue what to do here.
And the problem is the debt settlement company, they're not lawyers. They don't come in and defend people. They negotiate settlements and
Yeah.
this proceeding here. I'm going to go ahead and grant their motion for summary disposition. There's no genuine issue as to any material fact. I'm going to grant this pursuant to MCR 2.116C9 and C10. I'm going to ask you, counsel, to go ahead and give me your breakdown, if you would, please.
Yes. Damages $6,391.03. Court costs of $148.10 for a total of $6,539.13. We can go ahead and submit an order unless there's I don't know if there's an order in your file, Your Honor.
Let me see. I don't believe so. No, you're going to have to submit a judgment. So I'm granting this motion. The total judgment amount, sir, is going to be $6,539.13. If you choose to, you can file a motion for installment payments where they can't garnish your wages. You can do that going forward, okay? You
Okay.
might want to sit down or at least call Mr. Begg and speak to him about setting up an installment plan
Okay.
with his office in regard to this debt. And then as long as you make those payments as agreed upon, you will not have your wages garnished. Now, they could garnish bank accounts and tax returns and the like, but not wages. So that's your options. I sincerely wish you well. Do you have any question, Mr. Hazy?
No, sir.
All right, anything else, Mr. Begg?
No, Your Honor, he should contact attorney of record, Jeffrey Beers. That's noted on his notice.
Okay, so you can contact Mr. Beers.
Okay, thank you.
He's listed right on there. I wish you well, Mr. Hazy. Thank
Thank
you.
you. Bye.
Thank you.
Thank you.
Hold those, Tabitha, please. Can you give them to Tabitha? Yes, sir. Sean Allen, Norrock, 25W838719. Norrock up to the podium, and then I'm going to have Justin Nichols and Rana Barrow seated at the table up here, my right, your left. Sir, your name?
Sean Allen.
All right. Let's see here.
Right there.
You got to be careful, Mr. Norrock. You're in a school zone here, right? Right?
Yeah.
To the charge impeding traffic, that's what you want to do is plead to that, right?
Yeah.
Responsible or not responsible?
Responsible.
Please accept it. Original charge dismissed 160. Cashier into the hall to your right. Good luck. Thank you.
Sure.
Justin Lee Nichols, 25W838679.
Morning, sir.
Your name?
Justin Nichols.
Colin, you're gonna have to go talk to you don't qualify for impeding. You're gonna have to take this to the lieutenant there, and he's gonna have to figure out something else, okay? You gotta slow down, sir. Rana Akram Barrow, 25T645713. He doesn't qualify.
Good morning.
Woodhaven. Okay, so you're going to plead to impeding traffic, right?
Yes.
Responsible or not responsible to that? Okay, you gotta be careful, you're accumulating tickets, 170 is your total. Cashier, pardon? You're welcome, slow down, please, good luck. Lauren Marie Prater, 25T645664, could I have seated at the table, Kassam and Barner, right there at this table, my right, your left. Ms. Prater, you can come on up, state your name.
Lauren.
All right, you're going to plead to impeding traffic, right? Okay, just be careful to that charge, responsible or not responsible. 160, cashier under the hall to your right, okay? Slow down a little, thank you. Ali, the four, Gizem Kassam, 25T645734. Good morning, your name?
Good morning, Ali Kassam.
Got to take your hat off, sir. So, you're going to plead to impeding traffic, correct?
Yes,
To that charge, responsible or not responsible?
responsible.
Okay, I'm going to accept the plea, dismiss the speeding, 150, okay? Cashier into the hall to your right, good luck.
Thank you, Your Honor.
Javon Terrell Burner, 25T645740. Good morning, your name?
Good morning. Javon Barney.
You're going to plead to impeding traffic, true?
Yes.
To that charge, responsible or not responsible?
Responsible.
Please accept it, 170, cashier into the hall to your right, okay? Good luck. Aiden Michael Kraft, 25B148724. Your name?
Aiden Michael Craig.
So as I understand it, you paid this, and then you asked for a hearing, And then you met with the department rep, and he's gonna offer you 5 over, right?
Yes, sir.
To the charge of 5 over, which is 1 point, responsible or not responsible?
Responsible.
You're 18, 17?
17.
Where's your mom and dad? Either one here? Tell your son to slow down.
I have.
78 and a 50.
Yes, sir.
You want that good look in the face of yours marred by the windshield or something else?
Yes, sir.
Slow down, okay?
Yes, sir.
These vehicles are not a toy. 175 is your total, original charge dismissed. Please slow down, okay?
Yes, sir.
Good luck.
Thank you.
Ali Ayed Elte, 25B148851. Could I have Darian Chico, I think it is, CHECO, seated at the table? Your name, sir? You're going to plead as charged to this? All right, that's 2 points. You're aware of that, right?
Yeah, when I was driving.
I don't need to hear about it. I just want to make sure you're aware of that.
Yeah,
Okay, to the charge failed to yield to emergency vehicle, responsible or not responsible?
I was responsible.
I'll accept the plea. Got to be careful.
You can stay. Or you want to stay?
You got to be careful. 165, please accept it. You can go down the hall and take care of that. Slow down, be careful, please. Darian,
What's the last name on that one?
this one is Elte, Laltaeee,
Got it, thanks.
and it's $160.
Good morning once again, everybody. Welcome to the Courtroom Files Live. Again, happy Tuesday. Nice to have you all here. Let's try something different. Let's head down to Florida. This is Judge Collier in Gulf County. We haven't visited with him before. He's doing a felony docket, maybe? What's he doing? Criminal docket. Doesn't say if it's felony or not, but let's see what's going on.
For the purposes of today, if we could waive his presence, since we do know where he is, he's not willfully intending not to be here. And they kind of all are connected, so they all happen. It's not like one is a violation of the bond or anything that I can tell. But so for the purposes of today, an information was filed. We'd waive that formal reading of the information and enter a plea of not guilty and just ask for the next pretrial date so I can speak with his counsel there about what's going on.
Okay, August pretrial work.
Yeah, that'll work.
Mr. Patterson, August work.
Yes, Your
All right, that'll be August 12th at 1:30.
All right, thank you, Your Honor.
Thank you. David Broderick.
Judge, this is David Broderick coming forward, case number 25102 CF. Mr. Broderick has filled out an application for the Public Defender's Office. I believe it's been approved.
It was.
All right, I'll appoint your office, Mr. Hill.
Thank you, Judge. The state's filed a one-count information charging sexual battery on a person less than 12 years of age. That is a capital felony. Minimum punishment is life in prison. Waive formal reading of that information and ask that Mr. Broderick's case be scheduled for pretrial August the 12th.
All right, Mr. Broderick, we'll see you August the 12th, sir, at 1:30.
Is it possible to get my discovery?
Yes, sir. When I get it, you can get it. Here you go. That's a copy of the information. Like I said, when I get the discovery, I'll come see you at the jail and we'll go over it.
Catherine Conley. Ms. Conley, good morning. How are you?
Good morning, I'm fine, and you?
I'm doing well.
Good.
Ma'am, you're here for your arraignment? Has the state filed an information? Ms. Conley, do you have an attorney?
Yes,
And who's your attorney, ma'am?
Leanne Sedlick.
I don't see a notice of appearance for You said Leanne Fenwick?
Sedlick,
Sedlick?
yes, Seidlich.
Okay.
I just signed the contract last night.
All right, so what I'll do is I'll enter a not guilty plea on your behalf. We're gonna come back next month on, it looks like July 8th at 1:30. Make sure your attorney is here, okay?
Yes, have a great day.
Brian Carver?
Judge, this case is actually still in returnable status. State's still reviewing it. However, Mr. Carver does have a case that's already on your pretrial and motion hearing docket this week.
Okay.
So I guess for docketing purposes, it'd be appropriate to keep him on the returnable docket for next month. But obviously, he's got other matters going on right now, too.
All right, we'll bring you back for an arraignment next month, Mr. Carver. That's July 8th at 9:30. James Clayton? Morning.
How you doing?
I'm well, sir. How are you?
We're good.
All right, Mr. Clayton, you're here for your arraignment. The state has filed, looks like, a 4-count information against you. Do you have an attorney?
Yes, sir. Don Dennis.
Mr. Dennis is going to represent you?
Sir?
Is Don Dennis going to represent you?
Yeah, I hired him.
He hasn't filed a notice of appearance. When was the last time you spoke with Mr. Dennis?
I haven't spoke to him since I've been locked up.
When did you hire Mr. Dennis?
But I had him, someone tell me that he's supposed to come down here and talk to me. But I hadn't seen him.
When did you hire Mr. Dennis?
Just a few days after I got locked up. So I can't remember the date I got arrested. Well,
And you paid Don Dennis or had a family member pay Don Dennis?
yes, sir.
You signed a retainer agreement?
Hmm?
Did you sign a retainer agreement with Mr. Dennis?
I hadn't signed anything. I had money sent to him.
All right, so what I'll do, Mr. Clayton, I'll enter not guilty plea on your behalf. We'll come back next month. That'll be July 8th at 1:30, and
Yes,
make
sir.
sure you have Mr. Dennis.
And I'll check in with that situation.
Okay?
All right, this all seems fairly procedural there. I'll keep an eye on it. Let's go to Texas and we'll say good morning to Judge Stevens, see what he's got going on today.
All right, hold on. Let me get it. Sure. We go through all this to make sure that the important thing, Mr. Collins, he's a very good man. You're here, but the important thing is you make a wise choice and you move on with your life in a good direction. And hey, everybody makes a mistake. Everybody makes mistakes. It's just how you fix them. You can do it. You can. I think you're a very capable man. Being able to fix this, get on the right track. And we won't have to see you move on with your life, you know. This is stuff that's, I think, is fixable.
Yes.
Who's the prosecution?
Mr. Eckhart on this case.
Who's got comfort in him, Mike?
Judge, what I wanted to do I think we can move this case to me, but what I did want to do when Mr. Eckhart arrived.
Yes, sir. Oh, okay.
Right. At least on the first case, the unlawful possession of a firearm by felon, the gentleman to my right, stand up. you know, he, it was his gun.
Boss everybody, right?
Right. He was gonna talk to him, to kind of tell him that, hey, he was the one who actually left the gun. Now, as far as the other case, I mean, it is what it is. So I was hoping that I can move that one today.
Okay, when he gets here, you'll talk.
When he gets here.
Okay,
Right.
he's on his way. Yes, yeah.
Right.
All right.
So I just want to ask Mr. Collins to have a seat, and then Mr. Eckhart be here. So Mr. Eckhart could actually talk to the man himself. And that way, whatever he concludes. And then we'll just try to move everything today. So let's just wait for Mr. Eckhart to see it. Well, wait till he's better let you know about it.
I'm looking at the gun case now, there's no. Talk to Mr. Adams and. Okay, in the sequence, it looks like Mr. Collins gets arrested, on May 23rd. And then is indicted in October of 2024. I think it was unlawful possession of gun, but so he arrested in May. And then August 13th. Is he arrested again?
No, sir.
Says on Tuesday, perform an annual address verification required upon report. I learned that he no longer lives there. Still reported an address. As of this date, he has not reported an address change. So, but what had happened, you must have posted a bond on this first arrest. Hold on May 23rd, right? And then thereafter, you get an indictment on 10/16. So both of these cases were indicted on the same day by the grand jury. When did you post a bond on this second case? Do you remember? I've got it. 11/27. Okay. What is your current address right now?
I'm in Circle Q.
In San Augustine?
Oh, no, sir. In Orange.
Okay. I've got a San Augustine address on this first indictment. I've got Groves, Gulfway Drive on the second indictment. And you've got, what is your final address? The final one you want to use?
9 Circle Q is the address.
Sir?
When they went to the wrong place up there.
What's your address?
9 Circle Q, Orange, Texas. Seven 7630.
77 what?
630.
630.
Yes, sir.
No.
It's because right like it's he left his gun there, but when she got stuff at the plant, he told him, I'm sorry, I forgot to stay with her.
You got stuff. Like I said, I'm sorry, I forgot I had it in there. You don't say, oh my gosh, I'm surprised it's funny. I did not know anyone said that. Just tell you what he said at the scene. I'll wait till Sunday gets here, he talking, because I'm not, you know, I. Thank you.
Okay, corrected this. So we're gonna wait for Sonny to get here?
Yes, sir.
Is that it? Okay, stand by then, so have a seat. And Langston, you've got Leon Goodman, the third.
He's hired a lawyer and he's here.
Thank you.
All right, I'll keep an eye on that, and we can come back to it when everybody is present. Let's stay in the building, though, and we'll go over to Judge West's court.
Hugh Wadsworth. And Mr. Wadsworth was previously in court and entered a plea of guilty to the second-degree felony offense of aggravated assault with a deadly weapon. There was an agreement for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes.
Are there any additions or corrections?
No, Your Honor, not from this.
All right, Mr. Rojas, you may proceed.
Yeah, Judge, this is a cap of 8, the agreement, I think it's a cap of 8, and just based on the criminal history alone in the PSI, it looks like.
It looks like you did a very good job of getting that agreement.
That's kind of what, not that I did a good job, but I think that may be doing a favor to Mr. Wadsworth. However, Judge, there are some things I'd like to point out. If you look at, and I'm talking about his felony criminal history. The first page of his, I guess, rolling into this second page of his felony criminal history, most of those offenses happened in 2002. So he seems to be getting those in bunches. Those happened in 2002. He got sentenced in 2000. All one. In January 2002, they all happened.
Right.
Got revoked in 2003 on all of them. I think he did 60 months on all of them. Got some more in October 2002. Then after that, he goes in. Basically, he's in and out until about 2019 when he picks up some more cases. And from 2019 to this present case,
From after the 2002 and to the 2019, there were seven additional felonies.
Yes.
7 additional felonies.
Yeah.
Go ahead.
And then from 2019 to now, at least, he's able to stay clean. So he tells me that most of the time when he's committing offenses is when he's off his medications. He's been back on the meds now in jail. It's helping him. He's able to think clearly now. We talked about this, and if the court's even going to consider probation, as pointed out in the PSI, the only way he's going to get probation is with APD to help with his drug issues. He understands that. He recognizes that. He's willing to do that. He's hoping that you give him a chance to do that. And even as he was pointed out by the probation officer in the report, he's indicated to them that he's tired of this lifestyle. He's tired of being in handcuffs. He realizes he needs help just to make his life better. And he tells me he's ready to make that change. And he does have some statements to make to you at the appropriate time.
All right, go ahead, sir.
I only wrote this because I get really nervous.
Sure.
So I said, this letter is to ask you for some help. I'm a drug addict. I can't. Oh no. Basically, listen, man. I was a bad kid until I was ADD poster child. I was put on Ritalin. Then I did really good. The Ritalin, I went from straight F's, farting in class, thinking it was funny, picking my nose and eating it, all that stuff. I thought it was, I just was bad. They put me on Ritalin, I went from straight F's to straight A's. I was sexually abused. My parents were drug addicts. I went to prison. You guys forgot something. And I hope it don't hurt me, but I got beat up. I had a robbery in 1992. When I got out from that robbery until 2000, when you started, 2002, yes, ma'am. I stayed out of trouble again because I was on medication. It's been my whole life. It's been the pattern of my life. I'm on my medication. I'm a great guy. I'm a journeyman electrician. I'm a father. I'm a grandfather. I spend time with my kids. If I'm off of them, and the reason I got off of them and this offense happened is, I was hearing voices. I thought my roommate was holding my girlfriend hostage. It says I hit him with a bat, but it was my walking cane. It wasn't a bat. And I did hit him, and I felt horrible because I found what was going on in my head. Our house burned down, dogs died, and I just kind of went crazy. But I did stop. I did tell in 2018. I'm sorry, 19. I said I'm tired of this, and I'm gonna stay on my medications. When the house burned down, all my medications went with it. My truck, my tools, and everything. And I was just barely making it. And I honestly thought my roommate was holding my girlfriend against her will and hostage. And we started fighting. I was losing, and I hit him. If you do give me the chance, what I need is some help staying on my meds. Because I start feeling like I'm doing better sometimes, and then I stop taking them. When I stop taking them, I hear voices, and I can't tell if it's mine or if it's somebody else, or I can't tell.
So, but Mr. Wadsworth, here's the thing.
Yes, ma'am.
And I appreciate what you're saying, and I feel like you are sincere in what you're saying.
Yes, ma'am.
The problem is you're 51 now, 52?
51. Ma'am.
51.
Fixing to be 52.
And you know you've had these issues.
Yes, ma'am.
You've been given opportunities, and you know I need to be on my meds. And even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take a chance with society and the community of you hurting someone else. Honestly, I'm not sure, but I honestly think that you have the worst criminal history I've seen.
I even said that to Mr. Rojas. I said this.
You have 19 misdemeanor convictions. You have 20 others that were either filed, dismissed because of pleas on the other cases. So technically about 39 misdemeanors, 21 felony convictions, 21. I know, wow, right?
I'm not.
You still have one pending in Indiana. And out of and in addition to the 21 and the one pending, you have 16 others that were dismissed because of plea agreements, and things like that. So that's 38 felonies. The last, and I get a lot of this was from 02, and a lot of it was in the same big scenario.
19 of them was in one.
But it didn't stop then. You were put back on probation in 2017. So not that long ago, given a probation, it was revoked. So you were given an opportunity. Mr. Smith.
I've completely stayed out of trouble since then, though. Not one single incident.
Well, you had 2017 an unauthorized use of a vehicle felony. 2018 an obstruction of justice in Pike County.
Yes, ma'am.
2019 an escape. That's the one that's pending. Hold on.
Oh, I'm sorry.
And then another later in 2019, maintaining a common nuisance of a controlled substance or something like that in Indiana. So the last thing is 2019, which is, in the big scheme of things at your age, not that long ago.
I know, I understand.
Mr. Smith?
Judge, I would point you to his account of probation where he said the part about the baseball bat is not true. A dresser fell on top of it.
I saw that.
He's still not accepting responsibility.
I hit him with the cane.
Hold on, don't speak over. I let you talk, so don't talk over anyone else, please.
I believe probation is absolutely right that jail time and probation has not been a deterrent for him. He's not made probation. We would ask for the 8-year sentence. TDC.
Mr. Wadsworth, again, like I stated before, to Mr. Rojas, the fact that he was able to negotiate for you a cap of 8 years on a second-degree felony with your criminal history, there's part of me today that was considering not even accepting this plea agreement. Because I think with your criminal history, personally, I think it's ridiculous.
I have to understand.
So I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find that you entered your plea of guilty. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. There's help in prison for you with medication. It's going to be up to you when you get out to either change your life if you really want to or not, and you'll have to do that on your own. All right, good luck to you, sir. You can go back with the bailiff. Try again, same number. All right, let's see, Mr. Nichols. We're going to try again on Christopher Norris.
Dorothy, can I help you?
Hi, this is Judge West. I'm calling.
Hello.
How are you, ma'am?
Good.
Good. Do you have Mr. Norris with you?
We have got him coming on his way right now.
Okay.
To retrieve him from class.
Okay. Just let me know as soon as he gets there.
Wonderful. Thank you, ma'am.
All right, that may be a bit. Michael, get your vote in early. Let's go to Louisiana, do a parole hearing.
And we're working on a case on Mr. Deloyd Marigny. Is that you, Mr. Marigny?
Yes, sir.
Would you go ahead and state your full name and your DOC number for the record?
Deloyd LaJuan Marigny, 52-1768.
That's correct. Do you have a parole revocation questionnaire in front of you, the sheet you signed about talking about preliminary hearing and appointed counsel?
Yes, sir.
And that's your signature down there?
Yes, sir.
All right. And at that point, you were determined not eligible for appointed counsel. So we're going to go ahead and continue this hearing on without the appointed counsel.
Yes, sir.
All right. I'm going to read you a violation and ask you to plead guilty, not guilty, or guilty with a statement, not guilty with a statement. And then that's it. We'll move to the next one. We'll get into them a little deeper further in.
Yes,
so it's alleged that you have violated condition number 4, that you failed to refrain from criminal activity was evidenced by your arrest on November 14th by St. Tammany Parish Sheriff and charged with domestic abuse battery, resisting an officer by refusing to identify, disturbing the peace, and simple assault. On May 19th, 2025, you pled guilty to disturbing the peace. How do you plead today to that charge?
Not guilty with a statement.
Okay, hang on. All right, the second violation you have is number 10, that you failed to stay current on your supervision fees as evidenced by a arrearage of $691 as of 11/26/24. How do you plead to condition number 10?
Not guilty.
All right. Ms. Ledoux has been assigned your case. She's the lead person. She will take over and interview you regarding your statements.
Okay, so, sir, you pled guilty to disturbing the peace, but what do you have to say on allegation number 4?
I didn't plead guilty to that. I was found not guilty on 3 of the 4 charges. The court found me guilty of that because there was a fight in which they deemed me as, not the aggressor. I was defending myself as a 3-on-1 situation. So the court found me guilty because the cops were called, but I didn't plead guilty to that, man.
Okay, thank you for the clarification.
Yes, ma'am.
I'm not gonna address number 10. I'd like to, go ahead, I hear.
Can I say something on number 10? I was incarcerated for 7 months. I think my agent can tell you about it. And I was waiting to see that if they was going to expunge them payments because I was incarcerated, but it never stopped adding up. But my family been paying on it since I've been in here.
Okay. Yeah, that's not my primary concern today.
Yes, ma'am.
So do you want to just explain yourself for a minute and tell me what happened?
With the situation, me and my wife, we just had a argument outside. We was going through a rough time. Just had lost a baby. I just had lost my job. We had an argument outside, and I just tell her, come inside. Let's talk inside. The neighbors got in a situation. One thing led to another. I ended up fighting with 3 guys. And, they held me down, choked me out till the cops came.
I've watched some of that. We do have Aubrey, your wife, and she would like to speak. So I'm going to ask if she would like to make comments at this time.
Hey, good morning. How are y'all?
Good.
Yeah, I just wanted to say we just had a verbal disagreement that did lead outside, and I believe had the neighbors got involved, it would not have went any further than that. He wasn't the aggressor, so that's it. And I just believe that he should be let out.
All right. Thank you, Miss Aubrey.
Thank you.
Kyle Goldridge. Excuse me, I'll let you pronounce and introduce yourself, your supervising agent.
That's Kyle Gullidge. Yes, I'm supervising agent that took over Mr. Maroney's case in August of last year.
What would you like to present today? Do you have some insight from your perspective on his supervision?
As far as insight on supervision, like I said, I took his case over in August, saw him in November before the arrest, and that's all I've seen him. The only thing I have today is the arrest report and the video that was provided from the sheriff's office to the parole board.
Which I have watched.
Which was not admissible in court because it was video clips. Can I say that too?
No, ma'am, not at this point. Thank you, though. Mr. Deloyd, I watched the video clip. Maybe in your circle of friends, that's acceptable behavior. That's certainly not acceptable behavior where I come from. Okay, and I don't think that's acceptable behavior on supervision. You obviously were putting your hands in an aggressive manner, and harming another individual is not your wife. I watched how you jerked her out of the car. I mean, that's not acceptable behavior. You would agree to that?
I didn't hurt my wife. I wanted her to come inside, man.
You got to watch the tape now.
We use
And
words.
it is admissible at the parole board.
See, that is to your conditions that you will remain from any kind of physical aggressive conduct with any other person. Okay, that's the expectation, and that was not what I saw. That was not what I saw. You were non-compliant with the officer. You know, you're a 4th class offender. You know that immediately you should be able to identify yourself and comply with law enforcement. That's just a given when you're on supervision. And the fact that they even gave charges to that really concerns me. Okay. This isn't your first time. You've had other supervisions that have not been successful. I'm concerned about that. Do my colleagues have any questions?
Yeah, somewhere when we were looking through this file, I saw that you had a parole in Kentucky with a Miss Leisha Bosher. What's the status of that Kentucky situation?
There's a hold on me waiting on his disposition.
For violating the parole down there?
No,
Like
sir. For this,
trouble down here?
yes, sir.
Yeah.
No.
That was the only question I had. How about you, Mr. Freeman? I have no question. Thank you.
You know, what we have is evidence of aggressive behavior toward an individual, and that's not tolerated when you're on parole. If you have an argument, that should be verbal and not physical at all in any way. So my vote today is to revoke you based on non-compliance with your parole conditions.
Mr. Freeman?
My vote is to revoke violating condition number 4.
And I'm going to concur with my colleagues and also vote to revoke due to the violent nature of the criminal behavior committed while on supervision. So, Mr. Marigny, today your parole has been revoked. This concludes our business at St. Tammany Parish Jail.
Pretty much the standard result. Sad to say, but so true. Michael, once again, you call it. I just automatically assume when I go to these things that Michael's going to say denied, and he's unfortunately probably going to be right. Let's go to Miami-Dade. Judge Mindy Glazer, a.k.a. Judge Cranky Pants. Let's see how she's doing today.
Next is Lisbeth Hernandez, page 2. Ward D reset. Okay, let me do the juvenile case after that. After the ladies, I guess. Ward D reset. I'm appointing the public defender's office for her reset, Ward D. Then we have, I'd like to go back to the juvenile, Mr. Gabriel Wynn. I need a review for probable cause. You said, where's he, NBC?
Judge, can we do him this afternoon?
Yeah, I just have to review for probable cause. What's the information for?
This afternoon or tomorrow afternoon? I thought,
No, we could do him today, this afternoon.
oh, okay.
I don't know what the attempted murder charge is based on. Let me go look here. Maybe I'm missing.
There's another A form, Judge.
I think it's attached here. I just see resisting an officer one. I don't see anything here about. Oh wait, let me see. I think I got it now. No, everything talks about tampering with evidence.
No, there's a shooting on a different arrest form that I.
Fine, but they didn't provide it to the court.
I don't know.
Copied review for probable cause. Mr.
Yeah.
Not calculate, put everything together properly. Nope, I don't have it. So you need to provide it. Although an information has been filed charging him with let me see, blitzing and tampering. I don't have the A form. So I want to see that arrest affidavit for the attempted murder.
Yeah, I have it here, Judge. Do you want me to email it to you?
F25-12966. The one they gave me, it says warrant juvenile, order to take into custody. I don't have a copy of the order to take into custody.
Oh, okay. That's the only thing I have, that as well.
But there's an order to take into custody, like a judge signs a juvenile warrant. Well, tell him to get it. Call Mr. Bass and tell him we need it. Anyway, I'll reset it for the afternoon. The child's not brought over. You understand, Mr. Heineman?
Yeah, I found it. I found it.
You have it?
Yeah,
Order to take into custody?
yeah, I'm looking at it right now. I mean,
What-
it's the pickup order, correct?
Yeah, the pickup order, the juvenile
Yeah.
pickup. Can you email it to my judicial assistant? She can print it up and bring it
Yeah, I
down.
forgot. What's the first part of her email?
Letter I, ADORNO at JUD11.FL courts, COURTS.org.
No, I know I've sent it a number of times. I just forgot the first letter.
Yeah, I know. Sometimes it pops up. All right, so I'll reset it for the PM. Okay. Next is Louis Quintana Capote, page 4.
Your Honor, he needs the assistance of the Spanish interpreter.
Good morning, sir. Spanish, please. 1 second. Wait a minute, Iris. One second. Oh, she wrote her email address in the chat room for you, Mr. Heineman, okay?
Oh, okay, thank you.
All right, so good morning, sir. You were arrested for 1 count of grand theft of a vehicle, a first-degree felony, fleeing and eluding a police officer, and resisting an officer without violence.
Señor, fue arrestado por hurto mayor de un vehículo, delito mayor en primer grado, fugarse y eludir a la policía y resistir arresto.
I will appoint the public defender's office for you.
Voy a nombrar a la Defensoría Pública para que lo represente.
So I believe it should be grand theft, a third-degree felony. He allegedly stole a John Deere water pump equipped to a vehicle, which is an
Aunque yo creo que debe de ser hurto mayor cuantía, delito en tercer grado, porque supuestamente se robó un John Deere puesto en un camión, en un vehículo.
It's an agricultural irrigation water truck.
Es un camión agricultor, una bomba de agua. Un camión de agua.
He also, the police tried to pull him over in that vehicle and he refused to stop.
También que la policía trató de pararlo en dicho vehículo y usted se rehusó a parar.
Led to a nursery, subsequently crashing into a tree.
Que se metió a través de un nursery y chocó contra un árbol.
So count 1 is probable cause for grand theft, a third-degree felony.
Hay suficientes indicios racionales de criminalidad en cuanto al cargo número 1 de hurto mayor cuantía de vehículo, delito mayor en tercer grado.
Given that it's an agricultural truck, I don't know, how long have you lived here in Miami, sir?
Debido a que es un camión agricultural. Señor, ¿qué tiempo lleva de vivir en Miami?
5 años. 5.
Hable hacia el micrófono que no le escucho.
De 6 a 5 años.
6 to 5 years.
I'm sending a bond on count 1 at $7,500. He's destroyed this agricultural truck.
Ok, $7,500 es la fianza en cuanto a ese cargo de hurto mayor cuantía en el vehículo debido a que usted destruyó ese camión.
Count 2, fleeing and eluding is $2,500. Count 3, resisting without is $500.
Cargo número 2, $2,500 de eludir y fugarse de la policía. Y el cargo número 3, $500 por resistir el arresto.
You are ordered to stay away from the farm field at Southwest 137th Avenue and Southwest 248th Street.
Y se le ordena bajo orden judicial de mantenerse lejos y fuera de esa finca en la 248 del Southwest.
Good day, sir.
Tenga un buen día, señor.
her name? Would you be kind enough to fill this in at the top?
Since you're all talking about McNally and Glazer dating, let's compare them back to back. We'll spend a minute with Judge Dad.
Proceed here.
She is going to plead guilty to the violation, and I'm asking for the opportunity to allocate prior to sentencing.
Okay, ma'am, is that what you want to do? You look scared to death. Just relax. Just relax. This is the first violation. You don't have to apologize. This is a first violation. Okay? All right, but you do have to keep your voice up for me. So is that what you want to do, is to plead guilty?
Yes.
If you plead guilty, you understand again, you can get 5 days, right?
Yes.
All right. And again, you understand all your rights that I covered with you before. If you plead guilty, you're giving up all those rights, and we're not going to have a hearing. Do you understand that?
Yes.
To the charge, failure to refrain from consuming alcohol, testing positive on June 1 of 25. How do you plead? Did you test positive for alcohol on that date?
Yes.
Had you consumed alcohol, say, within the 3 days preceding that day?
Yes.
Anybody force you to plead guilty?
No.
Plea is accepted. Ms. O'Donnell, your name?
Just going on the probation.
All right. Mr. Nahikian, what would you like to say?
Yes, Your Honor. My client is obviously taking this very seriously. It's not a position she wanted to be in. She is working midnights. She's going to school full time. She actually had to take the leave from school to make sure she's getting everything done that she needs to get done in this case. I don't think there's going to be any future violations for drinking. I think this was a mistake, honestly. She has a little community service left. She only has $110 left on her fines and costs. If anything, I'm asking that the court add community service and allow Ms. Height to continue on her probation.
Where were you drinking at that day?
It was at her sister's house. Her sister's going through a divorce. And it was really an accident.
I'm not making an excuse for what happened, but.
I'm sorry?
I'm not making an excuse for what happened, but my sister just went through a divorce. I just ended up taking a drink out of her tumbler, drinking more than what I thought. I didn't know what it was because she's not much of a drinker. I would have deliberately drank something. I'm not making an excuse for it. I was strong. I should have known what I was doing. But it's not something I would have wanted to backtrack my progress.
Judge, she has been compliant otherwise. She did let me know right away that she drank. So she was honest about it up front, and we had a conversation of, not putting ourselves in those kind of situations. If she'd been honest with them about the fact that she wasn't drinking, that probably wouldn't have happened. But again, she was honest and upfront about it right away, Your Honor.
All right. Pay additional cost of $50. Serve 4 hours of community service. I'm going to give you until July the 15th to complete your community service, and I'll give you the same amount of time to pay your fines, okay? So, or your outstanding $50. So take care of all that by July 15th, all right?
Thank you.
Good luck. All other terms and conditions to remain in full force. Thank you.
Thank you, Your Honor.
People against Christopher Raymond Walker, 25W727443. Is that yours?
I don't have his files called in on somebody else, Judge, but I'm good on Mr. Walker.
Okay.
Good morning, Your Honor. We'll keep it with back to zero. That Mr. Walker was present to my left. State name correct, Mr. Walker? Christopher Raymond Walker.
Give me 1 second, please. So I took his plea before. It turned out he was intoxicated. I think we gave him a PBT. So obviously that plea wasn't made voluntarily and understandingly, and we set aside the plea and the sentence. And you can go ahead and tell me how he's going to proceed now.
Yes, Your Honor. We are going to plea today. I just asked for the opportunity to allocate prior to the sentence being.
Ms. Wild, your name?
Elizabeth Westbation, Your Honor.
Is that what you want to do, Mr. Walker? If you plead guilty to this count, you do have one technical violation previously Therefore, you could get 10 days. Do you understand that?
Yes, Your Honor.
Did you sign the advice of rights?
Yes,
Did you read it and understand it?
yes, Your Honor.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, Your Honor.
To the charge that you failed to refrain from consuming alcohol, testing positive on May 19th, how do you plead?
Guilty.
Did you test positive on May 19th?
Yes, sir.
And did you consume alcohol, excuse me, say within the 3 days preceding that?
Yes, sir.
Anybody force you to plead guilty?
No.
Okay, I'm gonna accept that plea. I find it to be an accurate plea made voluntarily and understandingly. Remind me what happened again. What did he blow on the breathalyzer in here?
0.198.
You're not under the influence now, are you?
No, Your Honor.
All right. What would you like to say, Mr. Mahikian?
Yes, Your Honor. So obviously, last time here was not great. Mr. Walker understands that. I can certainly tell he's not under the influence today. He's a different person. He did do some jail as a result of that. He spent 2 days in jail. As soon as he got out, he had to try to get a new job. He did just get a new job. It's at Take 5 Oil Change. He has been complying with every other condition, and he was also doing IOP on his own. That got a little disrupted with having to meet with the tether agent and his anger management, but he's still doing that on his own. I just ask that the court allow Mr. Walker to continue on his probation. He does have heightened testing.
Did he post his bond that day?
Yeah, I believe so.
You posted $1,000?
I think it was a day after.
Well, I know, but did somebody post $1,000?
Yes, sir.
Do you see that, Lisa? I don't think I have there's a lot of papers over here. Let me double check, but I don't think I have a receipt.
I do not see a bond posted.
Where did you post the bond at?
Where did it get paid?
I'm sorry?
Like, where did it get paid at?
Yeah.
Yeah, Wayne County. My mom was the one who did
Oh,
it.
that's, if he posted at the jail, that's why it takes a little while to make it back here.
2 weeks?
I think he posted it and he might have had to wait to get the tether and then he was released.
I know, but that seems like a long time for them to be not sending their bond over. You understand how serious this is becoming now, don't you? You don't?
Yes, but not fully.
Well, you understand I could revoke your 7694A status. That conviction would remain on your record, would go on your record and stay there. Domestic violence, not good. Do you understand that?
Yes.
I mean, I placed you on probation in February. You're here on 2 violations. You come into court drunk last time. Who's here with you? What do you think?
Yes, Your Honor. I've had lengthy talks with Christopher. I think even last time we were in court, I had discussed that I think that his alcoholism is a bigger issue than I think he's acknowledging. I did communicate with his therapist at the guidance center. The therapist is recommending that he go inpatient. That's coming from his individual therapist. He, in the last couple of weeks, has not been compliant with his attendance at treatment. I spoke with him yesterday about the importance of staying consistent with his attendance. They're not prepared to remove him from the program due to his lack of attendance. But again, I think it's displaying kind of what he needs when it comes to coming in with a 1.9, almost a 2 in my office. To his credit, though, I did get the verification of his anger management program. I actually got that this morning. He did complete that program. He is compliant with the other aspects. He's always been great with communicating with me, but again, I think that this is a larger issue at hand than he's acknowledging.
You're on a sober link now, right?
Yes, sir. It's on my pocket.
He's been testing?
He has been testing. His sober link is through the county, so after today, he will have to return that to county, Your Honor, once his bond is done.
I do think if we could get that, soberly maybe ordered for a period of time during his probation would help. If you made it clear that it kind of keeps him honest with himself, and I do think that's his main issue right now, is just needing to feel like somebody's watching, just to keep him honest with himself.
So how do I put this to you? I ask you straight up if you know how serious this is getting, and you don't seem to have a clue. You tested positive. You came to court drunk. You tested positive back in April. Or at least that's when I heard the probation violation.
So you gotta take care of.
And now you're not going to treatment? Why aren't you going to treatment?
I think if he missed any treatment, it was due to the tether and the drops. And Wednesday, he had anger management at the same time as his IOP. So it's just, he had two requirements at the same time.
Yes.
So the Monday, I had ended my tech officer at 7 a.m. and I was there for a little bit because he was kind of telling me how the soberlink worked and what to do with it. Then I had to do a drop around, I think they go from 5 to maybe 7 or 8 or something like that. So I wasn't able to make it there because I would rather go, do my drug test than, miss a drug test and go to IRP. I thought it would be more important for me to go to DNA test.
I want you to do both.
We're there from 4 to 7.
You're gonna have to figure it out.
From today on, I know I'll be able to make it every day now. That's kind of what I'm hoping to do now. But it's just, there was so much stuff in the way. I didn't know really which one to go to. I didn't want to test and then go to IOP and then violate again, or
I'm only telling you, you're very close to going to jail today. Really close. I can't believe, I get the whole addiction thing, the alcohol problem. I get all that. But coming to court like that, how incredibly disrespectful. 0.19, my Lord. Come on.
I want to go podcast about that.
Well, I don't want your apology. I want you to stop this before you completely ruin your life. I'm gonna keep you on probation, subject to all existing terms. You're to pay additional, how often is he testing now?
Your Honor, I don't have his file with me. I apologize. I do not know that off the top of my head. If he lets me know what color he is.
Yeah, I only ordered monthly testing. That's going up.
He's mine, it's twice a month, Your Honor.
I'm sorry?
He's testing twice per month.
Okay, I must have increased it before. Let me just double check that. Yeah, I did. I think this is gonna send a message to you as to how close you are to going to jail. Pay additional cost of $100. Serve 2 days on the court work program and pay $70 for that. You're to be on a SoberLink device by the end of the day until September 1. You're to test weekly until September 1. If you're clean, I'll then revert it to bi-weekly for 4 months. If you're clean, then it will be monthly. So SoberLink device, beginning today until September 1, 2 days court work program, pay 70 for that. Test weekly until September 1. If you're cleaning bi-weekly for 4 months after that, then monthly, and $100 in cost. So you're 170. I'm going to say you can pay all of this by, I'll just say July the 20th. You will meet with probation. This is your last chance. You understand?
Yes, Your Honor.
All right. I wish you well. Thank you.
Thank you.
Thank you, Your Honor.
So I personally thought that would have gone a lot worse for him. I don't know about you guys. So while all that was going on and we had watched Judge Glazer before that, Ashley sent me a link that gave some death statistics. There we go. In Florida across the entire jail and prison system, which was interesting stuff. Suicides in the system peaked at 30 of them between 2022 and 2023. Their fiscal year runs from July to June. And then the 24-25 fiscal year, it had gone down to 14. But her sending me that got me digging, and I found an actual report for Miami-Dade County and their jail system. And they update this rather frequently, it looks like. This is from June 11th, so just like 2 weeks ago. But as of June 11th, that county, that system alone has almost 4,800 people currently in custody. 90% of them are men. The vast majority are between the ages of 25 and 44. 90% of the current population is either convicted of a felony or has a pending felony charge. So a lot of felonies there. 77% of that group are unsentenced. They have about 13 people. 12 people with the longest stays are all in their pending first-degree murder charges. 147 of the inmates have been in the jail for more than 4 years. 104 have been in there between 3 and 4, 219 between 2 and 3, 202 between 18 months and 2 years, and 302 between 12 and 18 months. So a lot of people have been there a long time. What else was it that I found interesting? Oh, yeah. So every day for the last 4 months, at least as of this report, they're never booking in really less than 100 people a day. There's a couple of days where it dips into the 90s. But most of the days it looks like it's around 120, and it spikes up probably on the weekends, if I had to make a guess. It's hard to tell from the graph, but it spikes up to as much as 200. But the release numbers for the last 4 months every day are lower than the number of people that are being booked in for the most part. There are some days that are exceptions, but that means overall the prison population is increasing. Or the jail population, rather, is increasing in Miami-Dade. So Ashley says the longer they're there, the less mentally stable. Maybe. I don't know. I mean, this report doesn't speak to the health of that population, but I found it interesting to share with you nonetheless, because if anything, it might explain why Judge Glazer is always so busy and always so stressed. She's seeing a ton of people every day. It's a lot of people. So just thought I'd throw that out there for you guys and make of it what you will. Let's go back to Texas. That guy we saw earlier in front of Judge Stevens, he's back. So let's see how this finishes up.
Oh, it's Brian Thomas. I recognize. Mr. Adams, what are we doing?
10 over 10. And to
I don't have any papers.
We said
Brian Collins, we have 2136 is a plea in that case, and 2135 is to be dismissed in consideration.
Okay, we now call 24 CR.
Fingerprints?
2136, the state of Texas versus Brian J. Collins, present with Mr. Adams, his attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about August 13th, 2024 in Jefferson County, Texas, you committed the third-degree felony of failing to comply with sex offender registration requirements. Do you understand what you are charged with here, sir?
Sir.
This is a third-degree felony, and this means that if convicted, you face no less than 2 nor more than 10 years confinement in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range for such an offense?
Yes, sir.
An agreement has been reached where you would be pleading guilty, sentenced to 10 years in prison. That will be suspended. You will be placed on regular probation for 10 years. And I don't see a fine. And 24 CR 2135, another case pending, will be dismissed as part of this agreement. There will be terms and conditions of probation, which are normally customary for this type of offense, which at the end of the day, it's essentially continue to comply with the requirements of the registration. That's the basic thing here. Okay, is that your understanding of the plan?
Right.
If I follow this agreement, you have no right of appeal.
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily?
Yes, sir.
It is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit. Did you sign that voluntarily?
Yes, sir.
Did you understand it? Discuss it with your attorney? Or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
And without objection, admitted. Among other things here, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily.
Yes, sir.
You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 made a part of the record for all purposes. No sentence report as well?
Absolutely.
Okay. I'm going to follow this agreement, sir,
Yes, sir.
and find you are mentally competent to enter your guilty plea. It's freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 here, admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of failing to comply with sex offender registration requirements. I'm going to place you on probation. You are hereby found guilty beyond a reasonable doubt, sentenced to 10 years in prison. That confinement is suspended. You were placed on regular probation for 10 years. You do well, we'll shorten it in a third. There will be terms and conditions of probation, which we are normally and customarily require defendants, as you in this type of case, to follow. And they're really not hard. Just do it and continue to faithfully register as you must. If you fail, your probation could be revoked. You could be sentenced up to 10 years in prison, which we don't want. So fix this. It's fixable. Sure.
Did it wrong?
Yeah, good one. Thank you. Yeah, but I got with I've marked through this thing a couple of times here already, so you got to slow down wherever you're moving around. Yes. Where they are. Please see the probation officer. Thank you.
Appreciate you.
And she needs his thumbprint real quickly.
Mhm.
And here the 2135 is hereby dismissed on Mr. Collins. Oh,
So judging from your comments, there was a bit of a hiccup there, whatever it was that I think it was on YouTube's end, because I've had no issues here. So I think it was them. We should have an IO emoji. We're going to work on that. I need more members before I can do more emojis. I'm maxed out at the moment. But yeah, no idea, guys, what might have happened with the stream. Everything has been great on this end. I've had no errors, no buffering, no nothing. I think it was on YouTube's end. So sorry about that. Michael, start typing. Let's go back to Louisiana and we'll try again there.
5657.
Danny Barlow, Chairman today. My colleague, Mr. Lee to my left, Mr. Freeman to my right. A remote location, Southeast Parish Detention Center. Is there anybody there?
Yes, sir.
And can you please introduce yourself for the record?
Sergeant Stommel and Sergeant Marshall and Corporal Bellegarde's here. Can you get our video here going?
Can you turn your camera on, please?
We're trying. That's what I'm trying now, sir.
Camera's being used by other apps. What's the arrow say? Is the arrow right? Mirror. Video set. Okay.
We just had it working.
I lost them too.
Yeah. Can you use your tablet?
So we'll stick here for a second and see if they get the audio sorted. If not, we'll move on, but we'll give them a shot here a second. Let me know, by the way, if you have any other issues with the stream as we go forward, because, again, everything's fine on this end, so it must be YouTube or Iran is following through with their threats to do cyber attacks, or who knows, but just let me know.
This is directly hooked to the internet. This ain't even no Wi-Fi. This is direct connection. Says it's streaming.
Can you please turn your camera on?
That's what we're working on now, sir.
We're working on it. We can't see y'all neither.
Yeah, I'm trying to log into the tablet now.
Oh, there they go. Okay. Hold on. Might be getting somewhere. The camera is being used by other apps. What does that mean?
We're switching to tablet.
Yeah, we're in the process of switching to a different unit. I don't know if it's broke or it was working and now they.
No, I just gotta go to that address.
Why was it working before they got on there and now it ain't working at all?
All right, this is far from gripping, so while they figure that out, let's go back to Judge Glazer.
Next we have is Alexis Perez Diaz, page 7.
Judge, he's out on probation violation F24222763.
Also the division judge. Is he here today? Good morning, sir. Mr. Perez Diaz, you were arrested for burglary to an unoccupied conveyance. I will appoint the public defender's office for you. There is probable cause for the charge. You're out on probation. There's a hold for you to see your judge tomorrow. And you speak English or no? Spanish.
Spanish and third grade.
Sir, Spanish. Ms. Obando, are you there? We have a Spanish interpreter? You want to call one? Okay. Where's Miss Obando? I want to call Spanish interpreter. Maybe she stepped away for a moment. Siéntate un momento. Necesito un intérprete para usted. Naquan Hannah, page 7. Good morning, Mr. Hannah. You were arrested for battery on a person aged 65 or older. Oh, now she's appeared. And resisting an officer without violence. I will appoint the public defender's office for you.
Excuse me, Your Honor. I was here last year. I've never been convicted or like anything like with criminal charges. This has all been domestic, like within family. You know,
All right, sir,
my
these
grandma,
are charges. You gotta chill out, all right?
I didn't put hands on my grandma. I just want you to know that. My grandma.
Sure. Everybody here is presumed not guilty. I rely on the four corners of the arrest affidavit. Let me review for probable cause. I didn't see grandma's age, although it says elderly person.
No, that's good.
Probable cause for battery. Sir, you are ordered to stay away from your grandmother, Linda Louise Mitchell. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, her home and school, and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. You may return to the victim's residence one time only within 48 hours of your release from jail with a police officer to retrieve your personal clothing, health items, medication, personal and business-related paperwork, and work tools. If you go to the victim's home without the police, or if you stay there, you will be arrested. Do you understand the stay away order, sir?
Yes, ma'am.
All right. I'll give him pretrial services, alternate bond. Count one will be $1,000. Count two is $500. Ordered in. Okay, just stay away from grandma. Have a nice day. Ruth Beer. So we have the interpreter. Let's go back to Alexis Perez Diaz, please. Good morning, sir. You were arrested for burglary to an unoccupied conveyance. I will appoint the public defender's office for you.
Buenas tardes, buenos días, señor Díaz. Se le ha arrestado por allanamiento de un transporte no ocupado y voy a nombrar a la Defensoría Pública para que lo represente.
There's probable cause for the charge. I'm setting a bond and it's $2,500.
Dictamino que hay suficientes indicios racionales de criminalidad y la fianza que fijo es $2,500.
Since you're on probation, you'll see your judge tomorrow for your open probation case. Have a nice day.
Y debido a que usted tenía una condena condicional, va a ser llevado ante el juez de esa condena condicional mañana.
Next, thank you. Next week was Pierre Vieira.
I got bone, so. Yeah, but you have a hold in your, another case, it's gonna be addressed tomorrow.
So I got called tomorrow.
Yeah.
Good morning.
Good morning, sir. Do you Spanish or English?
Spanish.
Sir, good morning. You were arrested for burglary to an unoccupied conveyance and criminal mischief.
Señor fue arrestado por allanamiento de un transporte no ocupado y destrucción de propiedad ajena.
Sir, can you afford to hire a private lawyer?
Señor, ¿tiene los fondos para contratar un abogado privado?
No.
No.
I will appoint public defender's office for you.
Se le nombrará a la Defensoría Pública para que lo represente.
There is probable cause for the charges of burglary to the unoccupied conveyance and criminal mischief.
Y dictamino que hay suficientes indicios racionales de criminalidad para el allanamiento de un transporte no ocupado y destrucción de propiedad ajena.
You're ordered to stay away from the victim's business, the Transporter Cargo Corporation.
Estoy emitiendo una orden judicial de que tendrá que mantenerse fuera y lejos de Transporter Cargo Business.
At 6320 Northwest 97th Avenue in Doral, Florida.
Ubicado en el 6320 Northwest 97 Avenida en la ciudad de Doral.
Sir, how long have you lived in Miami for?
¿Qué tiempo lleva viviendo en Miami, en la Florida? 19 years.
Okay. Pretrial services, alternate bond. It's $2,500 count 1 and $500 bond count 2. Have a good day.
Libertad bajo el monitoreo de pretrial services, alternativamente $2,500 en cuanto al cargo número 1 y $500 en cuanto al cargo número 2 en fianzas.
Thank you. Raul Almora Sierra is next.
Ashley, thank you for the public service announcement. Very good advice. Yes, everybody, change your air filters. By the way, I was going to mention, and I've been busy for those, most of you know, but my daughter's in town, so I'm a little bit distracted this week, honestly. But I wanted to thank everybody because this past weekend, we actually, for the channel, crossed the 10 million view mark, which is huge, especially when you consider that we're not even quite 9 months old here yet. So that's very much appreciated, and just wanted to thank everybody for all of your support. Let's try some Cajun Justice again. They have moved on to another contestant. So let's go over there and see how it goes.
37 a.m. My name's Danny Barra, serving as your chairman today. My colleagues are Ms. Ledoux to my left and Mr. Freeman to my right. Our remote location now is at LaSalle Parish Jail. Is there any staff at LaSalle Parish Jail in the room with you?
No, sir.
No? Okay. And would you please introduce yourself with your full name and DOC number for the record?
I'm Shaka Marquis Jones. DLC number 734-738. Currently housed at LaSalle Correctional Center.
Do you have a parole revocation hearing questionnaire in front of you?
1 second. I think so.
Look, it's up on the screen.
Okay.
You recognize that paper?
Oh, yes, sir.
And that was where they determined that you were not eligible for appointed counsel. So
Okay.
I'm gonna go ahead on and proceed with your hearing today without appointed counsel. Do you have retained counsel?
No, sir.
Okay. I'm gonna read you the violations against you and ask you to give me a plea to them, and you can respond with guilty, not guilty, guilty with the statement, or not guilty with the statement. I'm assigned your case, so I'm gonna be doing all the questions. The first violation you have is that you failed to report for the month of October, November of 2024 after being instructed to report monthly. How do you plead to that?
Guilty with a statement.
All right. And on October 14th, 24, you were instructed to report to your parole office and failed to do so. How do you plead to that?
Guilty with a statement.
And on or about October 24th, you moved from your listed address without permission, leaving your whereabouts unknown to the parole officer. How do you plead to that?
Not guilty with a statement.
And condition number 4, you were arrested for the offense of simple kidnapping, domestic abuse, battery, strangulation, as evidenced by your arrest in LaSalle Parish. On May 20th, 25, the charge of domestic abuse, strangulation with child endangerment and simple kidnapping were dismissed at the request of the victim. How do you plead to that charge?
To have been arrested on it, sir?
Arrested and having it dismissed.
Yes, sir, guilty.
And
with a statement, guilty with a statement.
And on November 4th, you refused to provide a drug screen during booking.
Guilty with a statement.
Okay, so you want to explain that, all of them.
Yes,
all
sir.
right. Well, let's go back to the first number 2, where you failed to report in October and November. What you had to say about that? What's the statement?
The first Wednesday of October, I was actually en route to my parole officer, and on our phone conversation, he stated that, excuse me, he stated that he had to leave the office early and that he had to go to his headquarters in Alexandria to take care of some paperwork. And he told me just to come back November, that everything was paid up and everything was okay. So when I was actually in my route to see him, the latest that I could have been there was 3:00 from appointment, and he was already gone from the office before I got there. And he told me just to come November, and everything was paid up and everything was okay.
And what happened? You got arrested before then?
Yes, sir.
Okay. And on number 2, part 2, you were instructed to report but failed to do so on October 14th. What happened there?
Well, I just talked to him previously the first Wednesday of the month, in which he had then told me that everything was okay, and then explaining to me when he said that I had to, once after my arrest, I asked him, could I present the evidence that I had on my behalf to show my whereabouts when the crime was committed? And he said that the warrants had already been signed, that I had to go to jail that day. And I didn't understand if I had evidence showing right then that at the time that the crime was committed, that I wasn't in the vicinity of the crime, how my evidence wasn't suitable enough for me not to go to jail. Like, because I had the evidence to where I was and a person
Did
that I
not
was.
report you just because you didn't like what he told you.
Correct. I can't deny that.
All right. And then number 4, you were arrested for the offense of simple kidnapping, domestic abuse, battery, strangulation by LaSalle Sheriff's Office. Tell us about that.
I was arrested on the offenses. As of why, I'm honestly not sure. but the mother of my child, once we had a conversation about the incident, like there was nothing besides I can't tell you why she called or what was her reason, but as far as me physically hurting anybody, I didn't physically hurt anybody, and I feel this is why the DA was ruling to dismiss the charges on both of our behalves. Because as far as a crime against anybody, like as far as harming anybody, I never committed a crime to harm anybody, and the kidnapping charge as far as on my daughter. I had permission to leave the residence with my daughter. So I don't understand how, with the evidence that I had on my behalf, I don't understand how I could have even been arraigned or arrested on the charges, besides the fact that I was on parole and, like, I don't know if there had to be an investigation or something, but as far as committing the crimes, I was never guilty of.
Well, I'm looking at the summary of the preliminary hearing. I can help you with a little bit of an understanding. It says here, Officer Davis observed Ms. Smith to have cuts on her lower part of her face, the same area as the just above, which was red in color and swollen her jaw, consistent with a fistic encounter. Ms. Smith stated that Shaka Jones was at her residence when he found out that she met someone while she was in rehab. Ms. Smith and Mr. Jones were in a previous relationship together and have a child together. Ms. Smith advised that Mr. Jones got her phone and called the male and exchanged a conversation with him. Ms. Smith advised Mr. Jones said to the man on the phone, "Don't worry, she's about to take your lick for you." Ms. Smith advised that Mr. Jones then slapped her in the face while she was holding the baby, and then she hit him back in an effort to defend herself. Advised Mr. Jones began to choke her until she lost consciousness while he was choking her. That's
Okay.
her story.
But I also have another statement that I gave to my parole officer, to where in her statement she said that there was an altercation, but the children wasn't home.
Mhm.
You,
Well,
you
you
sure?
both know different than what you're saying. That nothing ever happened.
Sir?
Said no. All of that says different than what you say. You say nothing ever happened.
No, what I'm telling you is there's also another statement that I provided to my parole officer, to where she says that there was an altercation, but the children wasn't home. And this is the evidence that I presented to my lawyer. Like, 1 minute the children was home during this altercation, and the next minute the children, like, she gave two different statements. But the evidence that I gave to my parole officer was also supposed to be presented to y'all, and I had that here with me.
Okay. How about condition number 4B, where you refuse to provide a drug screen during booking?
To the jailer, I actually asked if it was okay if I talked to my parole officer. Okay, the jailer at the jail, and he did tell me that it was no violation for me not giving the jail a drug test. As far as me being on parole, I was waiting and willing to talk to my parole officer about the situation, because I really didn't understand what was going on from the get-go. Because even after the charges was pressed on me, the mother of my child, like, we still communicating, and she's telling me one thing as far as that there's no charges on me.
You
So
got a
being
break.
arrested for, sir?
Got a big break right there when she decided she didn't want to press the charges. Okay.
Excuse
Is
me.
anything else that you want to tell us?
I don't want to just.
I don't see that there's nobody here in support. There's nobody here in opposition. So it's your chance to give us your final statement before we make a decision.
Well, my parole officer came by the house on August 28th to a home visit. I reported on the 4th, and 8 days later, he says that he came back and that excuse me, and that I wasn't home or whatever, and had already then moved from the residence. However, I was working 2 jobs, and how I know that I was on the clock on the 12th is because my birthday was September 24th, and I was picked up from the house that he said that I had moved from, and I went to my mother's house for a birthday dinner, and I was still living in both locations to where he says I wasn't there. Okay, around September 20th, I get a phone call from LaSalle General Hospital that the mother of my child had overdosed on prescription medications. And once I get to the hospital, I asked the doctor whether she was leaving, as far as the girl I was living with agreed that she could come stay there, or if she was going to get help. The doctor stated that due to the situation of her mental beings, he referred her to go get help. Okay, 3 days after my birthday, my birthday September, around September 27th, she was discharged from long leave from overdose. I went into a situation in my eyes as a helping hand. Okay, due to the fact that I was in a previous relationship with another female, I don't understand. Like, my intentions was never to hurt anybody, and the kidnapping charge, like I had permission to have my daughter. You know what I'm saying? And like the situation with the mother of my child, I just didn't see it fit. I was trying to help the fact that she had just came home off her overdose. You know what I mean? And trying to understand the mental being of a person that just attempted suicide. Like, my intentions wasn't to harm anybody. Now, should I have called law enforcement? I don't understand. I don't really understand why it would have been necessary, due to the fact that, like, there wasn't an altercation to where me leaving wouldn't have advanced anything. Like, I don't understand what calling law enforcement would have helped if there was nothing, no harm done in the situation.
All right. Okay, I guess does anybody have any questions, Mr. Ledoux?
No.
Mr. Freeman?
Was there any reason you didn't turn yourself in when the officer asked you to?
No, sir.
And how long have you been in jail waiting for this hearing? How long have you been in jail?
Oh, since November 24th.
7 months.
Yes, sir. And this might hurt me by saying this, but when Officer Norman contacted me, he said that if I met him with my daughter, that he could do away with the kidnapping charge. And I didn't understand, like, kidnapping. Like, my daughter was literally just given to me to take to my mother's house to get clean clothes and wipes and pull-ups. And this was less than 15 minutes after I left the residence of her mother. Okay, and then he said, and maybe the other girl, maybe you can talk to her to drop the charges. And when he said other girl, like, I didn't understand who or what he was talking about. And by me, the person that I was with at the time, I had been with the last 2 days. When he told me that the crime was committed, I was still with the same exact person that I was with when the crime was supposedly committed.
Have anything further, Mr. Chairman?
All right. All right, that would conclude the questioning. It's time to vote. Your case has been assigned to me. I'm gonna have to vote to revoke your parole due to failing to follow the instructions of your parole officer and the serious nature of the violations and criminal behavior that you have committed. Mr. Freeman?
I vote to revoke. I think he violated condition number 4 and number 3.
Mr. Ledoux?
Based on everything I've heard, you have been non-compliant with parole supervision. You did not obey the orders of your parole officer. And I do believe that what you call a conversation was a physical altercation. So my vote is also to deny your, to revoke your parole at this time.
So, Mr. Jones, today your parole has been revoked, and this will conclude our business at LaSalle Parish Jail at 9:54.
God bless you all.
So, to the surprise of nobody, the result there is parole revoked. Let's go to Texas. We will say good morning for the first time today to Judge Boyd.
4281A, State versus Vanessa Faye Rubio. Can I have parties announced?
Megan Galloway for the state.
Alfonso Otero on behalf of Ms. Rubio.
Are you Ms. Rubio?
Yes, I am.
All right. Did you review the document entitled Motion to Revoke Community Supervision and State's motion to supplement pending motion to revoke probation with your attorney? Did you understand it?
Yes, I did.
Are you the same Vanessa Faye Rubio who was placed on community supervision in 2023 CR 4281A for the offense of theft of a firearm on August 7, 2023 for a term of 4 years? Is that you?
Yes.
All right, state.
Violation of condition number 4 in Bexar County, Texas, the defendant Vanessa Faye Rubio did then and there fail to report to the supervision officer as directed for the months of April, May, June, July, August, September, October, November, and December 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True. In violation of condition number 4 in Bexar County, Texas, the defendant Vanessa Faye Rubio did then and there fail to report to the supervision officer as directed for the months of January, February, and March 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True. And we'll waive and abandon the remainders, Your Honor.
Any objections?
No, Judge.
All right. Did you understand by pleading true to violations 4 and 4, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility?
Yes.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes.
All right, the court will find violations 4 and 4 true. Is there an agreement or no?
No, Judge, it is the case we talked about that we
Yes.
need the medical.
No, I remember. I'm just trying to see if there's an agreement. All right, we can go off the record. So here's the thing. I did receive information that your client was in the hospital. I think the state is aware of that as well. So the real question is going to be when? And are we saying that she was in the hospital for these months that she did not report?
She lost her sight for a while, so we need the documents to see exactly what happened so the court can consider how that may have impacted.
I mean, I'll consider it, but we go back to whether or not these months that you've pled true to of not reporting, whether or not this was the time you were in the hospital. I mean, that's what I want to know. Because if this is not the time you were in the hospital, then you're being in the hospital, that's just sort of mitigation, but it's not really an excuse for not reporting. For example, April through December 2024, if you're in the hospital for all of that time, then the court will understand, okay, she can't do things because she's in the hospital. But if you were not in the hospital for those days, then the question that I would want, and I'm giving you all this information so that I can get this type of information. The question I would want to know is, where were you and why were you not reporting? And it goes the same for January, February, March 2025. Where were you if you were not in the hospital? You understand?
Mm-hmm.
So if you were not in the hospital during those time periods, you probably need to let your attorney know, because he's going to be seeking certain information to show that either probably that you were in the hospital or that you had some type of medical issue that you were overly concerned about.
Mm-hmm.
And that's why you didn't report. But for the court, it's easy to pick up the phone to call somebody and say, hey, I'm having medical issues. So this is the type of information I'm going to want. But if that information is not there, then don't have your attorney spinning his wheels to get information that does not exist. Do you understand? Okay. All right. So does this information exist?
I believe that it's considered a factor, yes.
I'm sorry?
I believe it's considered a factor.
All right. So, and you're not an oath. So my question though is, these dates where you pled true to not reporting, were you in the hospital?
I was not in the hospital, no, but I was seeking care for it was it was a big issue at the time. It was concerning for myself, and I spent more time concerning that. I did mess up and not call, and that's my fault. I pled true to that.
Okay. And so my understanding, you all don't have an agreement, and what would you be asking for?
Well, just give.
No, I mean, if you
Oh,
were,
well,
if you're just, I'm just trying to figure out where we are, so I'll know. What would you be asking for?
To keep her on probation, there's ISF recommendation, or whatever the court means necessary to bring the defendant in compliance, and having an opportunity to continue her treatment for her eyes.
All right, and state, what would you be asking for?
We're asking for revocation and 2 years in the state jail.
Okay, all right, so now I know where everyone is, and you know where everyone is. So how long is it going to take for you to get the information you're seeking?
I think the jail has him. I mean, I probably can try to, she's going back and sign a HIPAA for me. And once that's done, I just contact the jail and see what they have for me.
So does the jail have this information?
Yes, because I used UT Health for all of the treatment before I was incarcerated as well. So they have access to all the records.
Okay, so then maybe if you have one of the nurses there, if she signs HIPAA, then you can have the nurse Zoom in and testify if you want to do that.
That'd be great, Judge. Yes.
All right. And you say you have vacation. When would this be?
It's on the 26th to the 30th. This Thursday to Monday. I mean, I can cut it short and come back on Sunday.
No, I mean, Norma, can you recall this for July 8th? All right, is there anything else?
Nothing, Judge.
All right, and then what I discovered when I was a defense attorney, if you just call over to the jail and ask to speak to the nurse, once you sign your release, they should be able to give him the information very quickly, but you have to do your part, okay? And counsel, if there's an issue with communicating with them, just let me know. And if you want me to see if I could help expedite things, I'll do that.
Yeah.
All right, thank you.
I'm sorry, Judge.
Yes, it's going to be reset till July 8th. Defense counsel wants to see if he can obtain some medical records from the jail.
All right, we'll stay in Texas. We'll head east, though, and check back in with Judge Stevens.
On the third-degree felony of unlawful possession of a firearm by previously being a convicted felon. And that carried with it, it's a third-degree felony, so you were looking at no less than 2 nor more than 10 years confinement in prison. And you were ineligible for regular probation. So we've got really 2 options. The agreement that was made by the parties is that whatever sentence shall not exceed a cap of 4 years in prison. So you were looking at imprisonment no less than 2 nor more than 4 years confinement. You can also be placed on deferred or unadjudicated probation. But again, regular probation, the third option is not. Is that also, is that an option here in this case? Regular probation?
Your Honor, you're not limited from doing that. You can do that as well if you choose to.
Yeah, he didn't use the firearm.
No, sir, he
He didn't actively use it. He was in possession of it.
Correct.
So
that's correct, Your Honor.
So it was not used or in a way that would then prevent him from being placed on regular probation.
Yes, sir.
Everybody.
Yes, sir.
Go ahead. Mr. Grove, you may go first. And then Mr. Smith, you have a chance to be heard as well in the statement. Okay.
Right, Judge, Mr. Smith is not here to tell the court that he has not ever been in trouble or he has had any problems. He has had some problems in the past. He also has been
how much time?
He has been on deferred adjudication, I believe, on one occasion successfully completed it. He has one case which was revoked. He also, when he has graduated from high school and is currently attending Lamar Institute of Technology. He is
doing what? What's the plan?
Technology. Sir.
And what plan?
What P-Tech, well, process technology to get my social technology.
And what do you intend to do with it?
Like get a job in one of these plants like OCI, LNG, things of that nature.
Good.
And while he's attending school, he also has a full-time job. So he is spending his time well. He has 5 children. And he spends a lot of time with the 5 children every other weekend, basically. And although he's had some problems in the past, and I'm not trying to downplay that as much as possible, but he was stopped by the police with the firearm in the car. It was in his car. The weapon was found under the seat. It was an unloaded weapon, did not have the magazine attached, although the magazine was in the car. I'm not trying to downplay that. He told the authorities when he first was arrested that the reason he had the weapon was because he had gotten it from the children of his girlfriend to take it away from them. It was still in the car. He shouldn't have had it in there. There's no doubt about that. But he did. It was not as he was actively using the weapon or intended to use the weapon. Again, he has a number of arrests and a number of probations which he's been successful. But we'd ask the court to consider giving him one last chance and to allow him to receive either deferred education probation or regular probation on this case, and not force him to go to the Texas Department of Criminal Justice. And again, I point out that he did graduate with high school, go back to school and get his diploma. He also is continuing his education so he can support his family. And he's very sorry about this. I would ask the court to consider giving him probation.
Okay, stay.
I disagree with that. Judge, the thing I want to highlight, there's so much in this report, but the thing that really just rings so true is when on page 4, when he admits during his PSI that he's been daily smoking marijuana. That means that while he was out on your bond for this particular case, he was violating it every day. He was violating the law every day. It has a direct connection with the fact that the underlying felony that he's convicted of is possession of marijuana. It was a state jail felony amount. Yes, he did get probation for that. It was a straight probation that requires a conviction. But here's the thing about probation. The hope is that we're going to get somebody to rehabilitate.
Better.
Well, he didn't rehabilitate. He got out and he just kept smoking dope. Now, let's look at what the facts are of this. He was asked by the officers whether or not he had a gun. His response was, "Not that I know of." Then in the search of the car, not only do they find the gun, they find a magazine that goes with it that's loaded. They find an additional magazine to a separate deal. So it's not like he accidentally had some weapon here. And when he's given an opportunity to talk to PSI, he blames it on his quote unquote homegirl giving him that gun. And that judge, I was generous when I took what he got before and just doubled it from a 2-year sentence that was probated for 2 years to 4 years. His counsel kept coming back trying to get it, probation for him. That's not something I agreed to. I agreed to cap because I think 4 years is fair. I stand with making that offer suggested sentence today.
You want to say anything, sir? This is your time if you wish.
I have no excuses for what I've done.
I'm sorry?
I have no excuses for what I've done, but I know I'm trying to correct my life and just do better and stay away from all the activity that you see on my report. I'm trying to be here for my kids. I'm trying to right.
Yeah.
Yeah. So I'm the biggest role model. I'm trying to show them the right way to live.
Yeah, but what's going on here?
Bad decisions. I'm doing the wrong thing. Like that's not me. I'm not a violent guy. Like I don't plan on continuing doing these acts. And I feel like I will be probation served.
How many misdemeanor convictions do you have?
5.
It's your life.
Looking.
11.
11. So
You said 5? You don't even know? This is your life. You should know more intimately than anyone. I'm telling you something about you that you don't know about your own life. Then you got the illegal, that marijuana, Ellis County mess that you were placed on probation, regular probation for. And then that gets you the conviction. But yeah, you don't only have 9mm bullets in your car. You've got 7 AR-15 magazine loaded with 7 live .223 caliber bullets also on the rear floorboard.
Yeah.
And a separate 9mm bullet in the rear, on the rear floorboard behind the driver's seat. Plus, they located a chunk of marijuana from the center armrest. You were convicted of something in 2017, illegal possession. How many times? 1, 2, 3, 4, 5, 6, 7, 8, 9. I'm speaking 9 separate possession of drug charges. They were misdemeanors, but 9. It really, it's just as though you can't get out of the hole there. And then, I'm sorry, we forgot the felony, Ellis County that you were on probation for. That was a felony. And so you're mixing drugs and bullets. Great. And we know you're not going to throw a bullet at somebody. The bullets are in there because there's a gun that they were going to go into. They were a firearm, and they're 2 separate types of bullets.
Yes, sir.
And this is the vehicle that you drive the kids around into?
No, sir. I don't have that vehicle.
You used to?
Yeah, I used to. But I didn't have the firearms in there for the bullets. That was just that day.
Who drives around with bullets in the car only? Huh? Who does that? No. What are you doing it for?
Sir.
You can't even explain it because we all know why. It fits in a gun, a firearm.
Yes, sir.
And you're not supposed to have that. But this is foolish when you've got a family at home.
Yes, sir. correct on.
5 children, really?
Yes, sir.
5 children.
Do that. Support them as well.
You're mumbling. I cannot
I
hear
still
you.
support them as well. You know what I mean? I help out and I pay child support.
What's the role modeling going on with the marijuana and the bullets? What are you teaching the children, sir?
You're right. I'm teaching.
You think you're not role modeling properly?
I don't do it around them, but it's.
You don't do it around them. It's what you are.
Yes, sir. You're right. I made it a habit when I was 15.
It's what you are.
Yes, sir.
You are supposed to be setting an example for the children.
Yes, sir.
You're the role model. They're going to do what you do. You think kids don't figure out, the kids don't ever get in this car?
Wow, they all play sports now. I'm making athletes.
You were a child once.
Yes, sir.
You know you pick up on things. You're
Yes,
not
sir.
a dummy.
Yes, sir.
Children learn, they're always learning, and they're most impressionable from their parents. But you also completed a drug offender education program, 7 years ago, but you know we're serious about all of this.
Just might just beat you in the back.
You're not handling it seriously. I know you appear to be taking responsibility
Yes, sir.
and accountability for it, but this has consequences.
Right.
I mean, this is serious. You're looking at up to 10 years in prison for this charge. But you know better. You've been warned.
Yes, sir.
Anything else? Go ahead.
Yes, sir. Very briefly, Judge.
Yes, sir.
Apparently the probation officer who prepared the pre-sentence report views Mr. Smith somewhat differently from what Mr. Ham does. She says that he appears to take full responsibility and accountability for the offense. He is attending community college and is gainfully employed, as well as taking care of his children. She recommends that he stay on probation and receive some trainings. What she suggests is a moral recognition therapy, or that, and then also that he receive a substance abuse assessment, which obviously he needs that. There's no doubt about that. And I would ask the court to consider giving him one last chance because of the fact that he has done well on these other things, although obviously he has not done well on the possession of the drugs and the weapons.
Those are kind of important.
Well, yes, sir. And I'm not trying to say that those are important, Judge. I'm not trying to say he's an angel or anything like that, but he has done well in these other areas, I believe. And I believe they would, it's one of those things where at least he's done well on that. And I think he could still be saved and society would be better if he were able to do that. But of course, it's up to you.
All right. Anything else from anybody? If not, I'm going to find that, sir, you have pleaded guilty in this case voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 that was entered into the record on your entry of your plea back on May 28th of 2025 to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt. This is the agreement is whatever sentence shall not exceed a cap of 4 years in prison. Listen very carefully. You are hereby found guilty beyond a reasonable doubt. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. Do you understand what has happened today, sir? Do you understand? Right. Do you grasping that? That your family and everything else that you put secondary to other things. I'm going to hold you responsible.
Appreciate you, Your Honor. So,
Sir?
like I said, I appreciate you, Your Honor. So, I really wish I could go through probation and complete my terms and go through classes. Like you said, you have the last say so.
For the way it sits right this moment is you're not going to get that. You're going to prison. You understand? How many children are at home?
5.
Do you understand this is inevitable?
So this is serious, yes, sir. I know. So I
It's your choices that affect the family.
sir, and that'll be filled.
And Mr. Ham is actually right on the button on everything he says. You deserve 4 years in prison. This is what I'm going to do. I'm going to suspend that and place you on probation for 10 years. You're going to 10 years because you need it. There's something wrong here in your backsliding process. There will be terms and conditions of probation that you must follow. And you're on really the thin ice. You know what I mean? So failure is not an option for you. It'll be real fast. It won't take much of a violation, but you got no drugs, no guns, no bullets. You will complete this moral reclamation therapy class, and I am going to ask the probation office to look into any other programs that might be important here to help him complete this. This shows you did 2 days in the county jail. You're going to do more than that. And you'll do it you're working during the weekday?
Yes, sir.
You're going to do your weekends are going to be busy. You're going to check in to the jail on or before 6:00 p.m. and will be released at 6:00 on Sunday. And you'll get credit for 2 days each weekend. And you're going to do 90 days, 90 days, 3 months in the county jail. Hopefully this is like putting your hand on a stove. You're going to remember and do better. But note this is another conviction. Next time you're looking, I believe, as a habitual felon. The next time you're charged, which is a minimum 25. Try to rear a family doing life in prison while you're doing life in prison. If a family is important to you, you should come third. Great saying. Our Creator is first, others are second, I'm third. You ought to be, but you keep putting yourself first. And that's why you're here. And that's why you're suffering. Most importantly, your family suffering, others are, because of your bad mistakes and your poor role model. Fix that immediately, sir. Will you?
Yes, sir.
Do more than just nod and say, I will. You made a promise, you're making a promise to every court when you're in doing a case. I'm never going to get in trouble again. That's what I hear. But folks show up. You're just if you fail, you're not going to just be letting yourself down. Others who rely on you, who ought to be more important to you than your acting. Okay, anything else? No. You'll go over with the probation office, then you report, every Friday.
Yes, sir.
Until you get, because that'll be 15 weeks, 15 weekends. You get credit for 2 days. Could have been a lot worse. I'll see her and then her.
I've already got his number.
Anything else? Yes.
So, Bailey, I think you asked if he changed his mind. I don't necessarily read it that way. If I heard him correctly, when he was sentencing him, he said something to the effect of, as it stands now, you're serving 4 years. So I think that statement leads me to believe he was planning all along to probate that, but was more trying to get the guy's attention, but I don't know for certain. I think you also commented that I had shared statistics on probation success, and I don't remember exactly what they are, and I don't have time to pull them back up at the moment, but the longer it goes on, the grimmer it gets. And the younger you are, the grimmer it is. He doesn't seem to be super young, so hopefully he's got a chance, but we'll see. 10 years is a long time, especially for somebody with a history like him to keep himself straight, so we'll see. Third time's a charm? They have a female this time in Louisiana. Let's see if she makes it.
2025, and the time is 11:03 a.m. My name's Danny Barra, serving as your chairman today. My colleagues on today's panel are Ms. Ledoux to my left and Mr. Freeman to my right. The panel is at headquarters in Baton Rouge, and our remote location is the Louisiana Transition Center. Would the staff at the Transition Center please introduce yourself for the record?
Hello, LaTanya Chase, reentry facilitator.
Thank you.
I'll be the only one here today.
Thank you. And Ms. Gray, would you please introduce yourself for the record with stating your full name and DOC number?
My name is Michaela Jo Gray. My DOC number is 701699.
All right. I'm going to give you a brief explanation of the process. I'm going to read some information to the record, ask you to verify it. We're going to give you a chance to speak and tell us what you did to get yourself in jail and why you think you should be released. We'll ask the warden for some input. We're going to allow any speakers from outside or supporters in for or against to speak. And then we'll conduct your interview. Mr. Freeman has assigned your case. He's going to ask the questions, but let's begin the hearing. Today we have for parole consideration, Michaela Gray, DOC number 701699, who's a third felony offender, who was convicted of possession of CDS Schedule 2 with intent to distribute, possession of CDS Schedule 1 heroin with intent to distribute, and distribution of fentanyl on January 13th, 2022 and January 17th, 2023, was sentenced to serve a total of 10 years in the Calcasieu Parish Jail. Your parole eligibility date is November 13th, 25. Good term date is May 12th, 26, in less than a year. Your full term date is August 12th, 32. Does that information sound correct to you?
Yes, sir.
All right, and go ahead and tell us what you did to get yourself in trouble and why you think today's the day to let you go.
I got arrested for distribution of fentanyl. And I think y'all should let me go. I know what I did was wrong. Learned my lesson. I've been sober for almost 3 years now. I'm in the living balance class. I did reentry.
All right. Warden, do you have anything to tell us about her behavior there?
I'm not the warden, but,
You'll be good enough for us today. Thank
okay. Well, she has completed, pre-release, and she's also in my living in balance class. And she's been coming every day. She has no write-ups. She's been participating well and applying herself. And she seems to like, she's taking accountability of her actions. She's talk about a crime a lot in class, to take accountability. She's always on time. She hadn't missed any days of class. So that's about all I can tell you.
All right. Thank you very much for that input.
You're welcome.
Okay, today we have in support a couple of people on Zoom who would like to speak. We have Angela Jordan, who's in support, and your mother, and she's wanting to speak. Let's hear from Ms. Jordan.
Hello?
Yeah, we can hear you. Go ahead.
Yes, sir. I really think Michaela has learned her lesson. I've talked to her almost every day since she's been in prison. And she is very, very sorry for everything she's done. We talk about it a lot. She told me she accepted Christ as her Savior. She's read the Bible. She's going to class. We're just ready for her to come home.
Thank you. We also have Miss Crystal Alexander, a godmother, who's on Zoom and would like to speak. Can we hear from Miss Crystal?
Hello?
Yes, go ahead.
Okay, hey. I've watched Michaela grow up, and I feel like she is truly remorseful for what she's done, and she can make a change. She is capable of that. She does have a support system that could actually help her. I'm willing to help her. I mean, I do work full time, but I am committed to helping her and be supportive to her any way I can, anytime I can. And I believe that she could like live a normal life and be productive if she's given another chance. And she has gone through all the classes. Anything that she was able to do to make progress there, like she did it. Like she didn't have any reason not to. Like she was for every class that was available to her, and she's ready to get on with her life so she can be with her daughter and her family again.
Thank you. We also have opposition from law enforcement. The district attorney's office is opposed and wrote a letter saying that she was selling fentanyl being represented as heroin, which is deadly, while on probation for other drug cases. The sheriff is opposed, and the attorney general is also opposed to early release. The case has been assigned to Mr. Freeman, so he's gonna ask you some questions and start it off.
Okay, Ms. Gray, first off, I keep hearing about all these classes, but you have no good time. Why?
No good time.
You would be out right now if you would have taken classes. You could earn up to a year good time. You have 0 days good time.
I've been writing, and I was put in reentry in, March of this year. I pleaded in May, and then I got put in living in balance in May.
Okay, well, maybe they would put some of your credits down, but still, that's not many classes at all. Like I say, most people in your position would have walked out the door, we'd have never heard this hearing. Okay, I do think you need to look into some more classes. Okay, Max, about this, why was the original charge second-degree murder?
The lady had overdosed, and they said that I had given her the drugs, but I wasn't convicted of that.
Do you realize selling drugs does kill people, can kill people?
Yes, sir.
Do you take any responsibility for the death of that person?
Yes, sir.
All right, You have a lot of criminal history, pretty bad criminal history. Have you ever taken any long-term substance abuse?
I'm in one now. I'm in living in balance.
All right, what about the introduction of contraband charge? What was that about?
Whenever I got to jail, they had searched me twice and I had meth in my bra and I forgot it was there and they didn't find it until I got into the jail.
Okay. I see that you have a high need, which is another reason why, you know, I feel that you need those classes. I have no further questions.
Ms. Gray, in your master prison record, it indicates that you have a sheriff's office detainer. What is that for?
I missed my court date when I was here. Lula didn't bring me, and so they issued a warrant for me, but they're supposed to recall it.
Okay, but why did they have a detainer against you, whether you got to?
I had another charge, but I took care of that charge. I went to court in March for it.
What was the new charge?
They convicted me of distribution.
I'm sorry, say it again.
I got convicted of distribution of fentanyl.
Another fentanyl distribution charge.
Yeah.
So after you had the charge that you're currently serving, they also found you guilty, or they put another charge on you and they dropped that charge?
It was secondary murder, and they dropped it to distribution of fentanyl because I didn't have nothing to do with the woman's death. So they convicted me of the distribution.
And then they ran it concurrent with the time you're serving?
Yes, ma'am.
Okay, so that detainer is no longer active?
No, ma'am.
Make note of that, staff. I need to look at that. How long have you been in, Ms. Gray?
It'll be 3 years on the 17th.
And what was your length of sentence?
10 years.
So you've served a third of your sentence.
Yes, ma'am.
I don't have any other questions. Well, I do have one. Who is caring for your child?
Her grandmother.
Her grandmother?
Yes, ma'am.
Your mother or the father's mother?
Father's mother.
Okay. Thank you. That's all the questions I have. Yeah, we show that the detainer is still pending, so we'll need to look into that. Thank you.
Mr. Freeman, you're the first guy. I have no question.
All right, Ms. Gray, you know, you talk well and you sound well. The bottom line is you haven't taken any classes, gotten any credit, and you're gonna get out as soon as you take those classes. One of them is required, substance abuse. So my vote today is to deny, as your good time date is 5/12/26. And once you take enough classes, you'll be out. You can get up to a year of good time.
Ms. Ledoux?
Well, it seems like punishment. I think, actually, Michaela, the best thing is to leave you where you are so you can finish those classes. So you can have as many tools in your toolbox that you need to be successful when you go back on the street. And I wish you well, but my vote today is to to deny parole because you need to take life. Thank you.
And I'm gonna vote to deny parole also based on the law enforcement opposition. The crime committed while you were on probation already. And the good time date is less than a year out. So Ms. Gray, today your parole has been denied, and this concludes our business for the day at, no, it doesn't, no. This just concludes our business with.
So I thought for a moment there that there was a chance on that one, but not to be, I suppose. Let's go to Judge Boyd. This person who's stepping in front of her, I think I've seen her before. Let me know in the chat if she looks familiar to
Everyone, if I have not called your case, it's because I don't have your file. All right, the court is calling 2025 CR 0000174 and 2025 CR 007073. State versus Amanda Hernandez. Can I have parties announced?
Rick Pena for the state of Texas. John Young for the defense.
And are you Miss Hernandez?
Honor, it's an oddity in the system, but I have two Amanda Hernandez's right now, so I would ask that she be identified as Amanda Marie Hernandez.
You are Amanda Marie Hernandez?
Yes.
Counsel, in each of the cause numbers, did you receive all of the discovery and did you review it with your client?
Yes, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. In each cause number, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it?
Yes.
Counsel, I'm sorry, Ms. Hernandez, in each cause number, did you review the documents entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
And counsel, do you waive the reading of the indictments?
I do, Your Honor.
State, are you proceeding on the indictment as presented in each cause number?
For both cases, yes, Your Honor.
Ms. Hernandez, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
In the cause number ending in 7-4, you're charged with fraudulent use or possession of identifying information less than 5 items. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
In the cause number ending in 7-3, you're charged with injury to a child or elderly or disabled person, bodily injury. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I do.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call on the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cases? Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes,
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she is and was.
Mr. Hernandez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, did you review the plea bargain agreement with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the causes are to run concurrently. The state is taking in consideration 2024 CR 011068. In the cause number ending in 73, there is a affirmative finding of family violence. There's to be no contact with the complainant or the complainant's address. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as a primary custodial parent?
Yes.
And in the cause number ending in 7-4, yes,
I believe with the 7-3 case, there was a fine as well.
a $1,500 fine.
And I'm going to
Then the
be
court
asking
is
the
gonna
court to
probate.
probate that. Your
Yeah,
Honor.
I will probate that.
Thank you.
All right, and then the cause number ending in 7-4. There is to be restitution to Audrey Bash, Roberto Alfaro, Arturo Olivares, and that's to be determined. Did you understand that to be the plea in each of the cause numbers?
Yes.
Defense is at the plea.
Yes, it is, Your Honor. I have also told my client that if there is any objection to the amount that probation determines as restitution, that I will ask for a hearing on restitution with the court.
All right, state is at the plea.
That is the plea, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
There have not, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 6 years. There'll be 100 hours of community service restitution, no contact with the complainants, anger management, TAP evaluation, follow all recommendations in MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then in cause number 2025 CR 000174, how do you plea?
No contest.
And in cause number 2025 CR 007073, how do you plea?
No contest.
State any evidence.
As to both cases, Your Honor, state offers into evidence, takes exhibit 1 with all attachments.
No objection, Your Honor.
All right, and state, have you spoken with the complainants?
We have, she's here, and at the conclusion, she'd like to give a victim impact statement.
All right, state, you may be excused.
Thank you, Your Honor.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand that by entering this plea, again, you're giving up your right to jury trial, a right to remain silent, and the right to cross-examine witnesses?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and will review the same.
Yes.
All right, in each cause numbers, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I know that she, even though I am retained, that she does not have any money in her own name. I was hired by a gentleman that is a friend of hers. I know that he intends to abide by this. I've explained to her that the court normally will review a request for early termination if she completes everything she does, has indicated to me she intends to try to do that.
All right, do you have any children?
Yes.
What are their ages?
They're a year older than 18.
All right, what are their ages?
25, 19, 18. Yeah, I don't even know.
You don't know?
I don't.
All right.
He wasn't in my life.
All right. When's the last time you were employed?
Prior to coming into jail, so, about 4 months ago.
Doing what?
Care.
And who were you caring for?
My best friend and 2 neighbors of his.
All right, who is Oscar Lara III to you?
Oscar Lara.
The person you were in the vehicle with when all of these cards were found?
In the vehicle, I was by myself.
Yeah. According to the stipulations, it says officer observed a male and female enter the Lincoln, and that's the Lincoln vehicle. Yeah.
Oh, that's Paul.
No, there's a Oscar Lara III. That's a different person. And you also have Paul Vasquez Jr.
Yes, Paul Vasquez is the one that was in the driver,
All right, so who is he to you?
a person I hung around with.
And who is Oscar Lar the third to you?
That I don't know. I don't know that person.
And who is Roberto Alfaro to you?
My ex.
All right, when's the last time you used any type of drugs?
About 6 months, 7 months ago.
And what do you use normally?
Heroin.
Okay.
I've been on Suboxone that's how I got off of it prior to coming over here.
All right, I understand when people say they're off of drugs and then they get on another drug, so they
Yeah,
won't use the
off of that,
drug.
But I had stopped, but yeah, I know.
I mean, it's still a drug, right?
I understand.
Do you have any violent history?
No.
All right, this is what the court is going to do. In cause number 2025 CR 000174. The court is finding there's sufficient evidence to find you guilty. The court will defer finding of guilt. The court will sentence you to 5 years deferred adjudication. This will run concurrent with 2025 CR 007073. Taking into consideration 2024 CR 011068. There's to be restitution to Audrey, Audrey Bash, BASH, Roberto Alfaro, Arturo Olivares, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release, no employment as a home healthcare provider or with minors, no residing with minors or the elderly. Field visits 1 time per month until further notice. There's to be a referral to felony drug court and Esperanza court in custody. And there is to be 150 hours of community service restitution and 60 sober support meetings in 60 days. Probation, is there anything else? Is there anything else you need from the court with regards to that case?
No.
And cause number 2025 CR 007073. The court will sentence you to a $1,500 fine. That will be probated. This will run concurrent with 2025 CR 000174. Taking consideration 2024 CR 011068. There's an affirmative finding of family violence. There's to be no contact with Myrna Espinoza Portillo or Yukon Boulevard. 100 hours of community service restitution, anger management, proof of employment within 45 days, no employment as a home healthcare provider or with minors, no residing with minors or the elderly, field visits 1 time per month until further notice, a referral to felony drug court and Esperanza court. That's to be done in custody. And in each cause number, there's to be a TAP evaluation in custody, follow recommendations. And there's to be 60 sober support meetings in 60 days. Probation, is there anything else? Is there anything else you need from the court in regards to that case? And each of the the term on this cause number is 6 years.
Your Honor, can I ask you to reconsider the referrals to both Esperanza and drug court in custody? I know that my client, part of her reason for entering these plea bargains was in order to get out of jail.
No. you need help, you have a drug or alcohol problem. And your drug or alcohol problem is what brought you here today. You understand?
Yes.
All right, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because these are plea bargain agreements, because I followed your plea bargain agreements, and because you waived your right to appeal, you do not have the court's permission to appeal. And cause number 2025 CR 007073, because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. In this court, communication is key. If there's an issue, you need to let your probation officer know about it. If you feel as though they're not addressing it, you can always come back to the court. Do you understand? All right, so here's the other thing. You're not allowed to be a home healthcare provider. You're not allowed to take care of the elderly. You're not allowed to take care of minors. If you do any of those things, it's going to be a violation of your probation and a motion to revoke is going to be filed. You also are not allowed to live or reside in any household where there are minors. Do you understand? And where there are elderly persons. You understand?
Yes.
All right, good luck to you.
Your Honor,
Yes.
the definition of elderly is sometimes a little fuzzy. My interpretation of that is it's a person over 65 years of age.
All right, so
When
let
they
me
cannot take care of themselves.
clarify. How old are you?
I'm 45.
You're 45. You cannot, Vashan, for her, 45 is 10 years older than whatever she is. So you're not allowed to live with anyone who is 55 or older. You understand?
Okay.
All right, thank you.
Your Honor,
And my understanding, there's a victim impact statement.
Yes.
just for your honor's edification, if it's okay, the victim would like to give it in Spanish.
Do you speak Spanish?
If I just, yes.
All right, so she wants to speak to you in Spanish.
All right. Well, she's cutting away anyways. I was going to say we're not going to do it in Spanish, but it looks like she's not going to stream that part. So leaving it up to me to break the tie, I'm going to go back to Louisiana because I want to roll the dice and try to end this on a good note. So this will be the last thing we do today. Let's see if it works out this time. Maybe, hopefully, fingers crossed.
Jail staff to give us some input on how you've been there, and any other comments from the public that, or the district attorney. And so let's begin. Today we have for parole consideration Rosina Como, DOC number 781884, who's a second felony offender who was convicted of theft of a motor vehicle between $5,000 and $25,000 and theft between $5,000 and $25,000 on September 8th, 2023 and June 21st, 2024. She was sentenced to serve 5 years hard labor, each count concurrent in Calcasieu Parish. Your parole eligibility date is August 6th, 2025. Your good time date is October 10th, 2025, which is about 4 months away. Your full term date is May 6th, 2029. Does that information sound correct to you, Ms. Como?
Yes, sir.
All right. As I said, tell us what you did to get yourself in trouble and why you think it's the time to let you out early now.
I stole a vehicle without permission. I used it and got caught, got in trouble for that. And then another time I stole a suitcase from the luggage baggage claim, and I didn't get away with that.
I think it's a good time for us to let you go today early.
Because I've learned my lesson, sir. I've learned my lesson, and I've taken classes for reentry. I've learned a lot about going back into society and being a positive civilian.
And which one of those classes did you learn the most from?
The reentry.
All right. I see that you don't have an attorney here to speak. I see there's no people on your behalf here to speak. I see okay. How about the jail staff there? Do y'all have any information you could share with us about her behavior in jail?
Ms. Como only completed, pre-release phase 1 and 2, and she's write-up free, that's all I know. She hadn't had any write-ups.
Right.
Why do I see, may I
Go
interrupt?
ahead.
I see that she has, you marked fair, as far as her institutional record, and I'm not following that. I don't know where that comes from. If you look at, her assessment,
Mm-hmm. And it says fair.
yes. Let's see. So on 5/14/25, Latanya Chase,
Mm-hmm.
institutional record is fair. I mean, look at all of this, and fair means it's not good, and I don't know why.
And it's off the, what they check and tell us on the, assessment. That's what we go by, what they check on the assessment.
Okay, thank you.
You're welcome.
Sorry to interrupt.
No problem. So we do have quite a bit of law enforcement opposition to early release. The judge is opposed, stating that it's too soon. The district attorney's office is opposed, stating you committed a new crime while you was already on probation. The sheriff's office is just straight out opposed. And the attorney general's office is opposed due to the criminal history involved. Mr. Freeman's assigned your case, so he's gonna go ahead and ask you a few questions.
Okay, Ms. Come on, how long have you served? How long have you been in jail?
I've been in jail since May 8th of last year, 2024.
So just a little bit over a year.
Yes, sir.
And you do realize that your date is in 4 months and that you got to take substance abuse and pre-release. That's a requirement. And by the time you finish those, once you get your good time, you would be out. Do you realize that?
No, I didn't realize that.
So no matter what we do today, you still got to complete pre-release and substance abuse
She's been finished pre-release.
and be out, but they hadn't given her the credit though for the time. So they need to get those credits to us and you'll be gone. Where do you plan on staying and living if you get out?
I plan on staying with my mother.
And any sobriety plan? Do you have any problems with drugs?
No, sir.
And the chairman already has stated with the law enforcement opinions. I have no further questions.
Do you have a detainer against you right now?
I do have a detainer in East Baton Rouge Parish.
And what is that detainer for?
I'm not sure exactly what the charges are. I think disturbing the peace.
Does stalking sound correct?
It could be, I guess. I don't, but I didn't, yeah.
Okay, so you have not been to court at all on that detainer?
No.
Okay. No further questions.
I have one. You said you don't have a drug problem. Why were you stealing? Why do you steal?
Well, I don't know. I guess at the time it would just seem like a good idea. I wasn't thinking properly.
Easy money, I guess?
Yeah. Yes, sir.
Not so easy when you get caught though, huh?
No, sir.
Okay. All right, that ends the question, and Mr. Freeman, it's your turn to vote.
Okay, Ms. Como, my vote today would be due to the proximity of your good time date and your mandatory classes to deny, as I state, soon as those credits or classes are taken, you'll probably be walking out the door. Well, go get your detainer taken care of. So you may want to look into that detainer now, so it won't be sitting there when you get out. But today my vote is to deny.
Yes, I do.
While it does maybe sound like punishment, it's not. You need to finish your classes and do the detainer. So my vote is also to deny. I hope when you get out, you're able to take care of your children and have a better life.
And I'm gonna also vote to deny based on the new charges were committed while you were on probation for a charge already and the strong law enforcement opposition. So Ms. Como, today your parole has been denied. Good luck to you. This concludes our business with Ms. Como.
Well, farts. I really wanted something better, but she might as well have just said when they asked her, why should we let you out early? She might as well have just said, cuz. That would have been just as effective. Oh well, they can't all be winners, and they certainly weren't from Louisiana today. But I hope you all had a good time. I did too. Some good stuff today. Channel members, you had a little back and forth, a couple of you in the chat about needing new emojis, more emojis, stuff like that. I am capped at the moment. We need like 27 more channel members before I can add one more emoji, or we have to retire some that we already have if you want me to change it up. So think about that and bring me your thoughts in the pre-show tomorrow if you want me to replace some of the existing emojis, and we can look at it that way. Speaking of which, though, we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour for channel members, half an hour earlier for channel members. We will do a third hour again, as we will all week. But again, hope you all had fun. Thanks for giving me your time. Again, I say it a lot, but I want to make it clear I appreciate it more than you know. So take care. We'll see you all tomorrow. God bless.